Good afternoon, everyone. Thank you for joining our webinar on Facebook Live with me, none other than Ms. Daniella Mair, a psychologist and somebody that loves family law and loves assisting families and people with problems. And she is a person to speak to. Daniella, how are you doing?
I'm doing very well, thank you. It's nice to be here. Nice to see you again. And yeah, I'm looking forward to this.
Yeah, Daniela, the last time we spoke was, yeah, I think a few months ago. Could have been, it was still this year, I believe, but it was quite some time ago. I do mention to people, these videos are all fresh. We might be repeating things that we mentioned in our previous videos, but the bottom line is we want to inform and educate everyone. If you have any questions, feel free to pose it, and Daniela and myself will try our best to answer it. But wonderful, let's go, keep going. Daniela, the topic today: family mediation and parenting plans. On the screen, I have a download link: www.ourlawyer.co.za/pp. You can download a parenting plan drafted by Daniela, and yeah, if you have any questions, feel free to contact us. Daniela, let's start with you. Any latest developments for the last few months? What's happening? You moved office. Give us some insight.
Yeah, so I've moved office, I've moved home, I've moved everything. Fresh new start, and everything's been going really well. I think that the main change that I've noticed is how people who have approached me recently are in a different type of mindset than they have been in the past. And I'm very excited to see that, how more people are realizing the value of knowing exactly what to expect and what to do before they start, as opposed to coming to us halfway, 3/4 of the way through a process and needing us to really like clean up a mess that has been created. So that's really exciting for me, because being able to start from the beginning the right way is so much more easy. It's so much easier to actually get a positive result all around. So that's very cool.
That's very exciting, Daniela. And I think with these webinars and with your webinars and you being out there, people are seeing family law from a different perspective, as opposed to the old perspective, which was very challenging, very gloomy, and very dark. But no, now they know the law, they understand the law, they understand that people like yourself, professionals like yourself, are there to assist them and trying to resolve matters. I think we're taking family law and family problems to a different dimension. Daniela, on the screen, clients can obviously see your details, your website, danielatherapy.co.za, and your email address and a telephone number. For those persons who are not um, watching the entire video, that might end off earlier, how do people get hold of you? Can they use those details, or do you have any other preferred way of contacting you?
No, however you'd like to contact me is fine. Those details: phone, WhatsApp. I prefer WhatsApp or email, because I'm often consulting, so I can't get to my phone all the time. But yeah, I'll definitely get back to you. But please, if you do want to contact me, just reference this webinar, or so that I know where you're coming from. But please feel free anytime.
Daniela, thank you for that. Something relevant now. This is a problem which I'm facing a lot. Um, parents having a problem in mediating what school a minor child should go to. I do not know if you deal with it on any basis, but what advice to get us ball going and kickstarting us? How would you deal with a situation where parents cannot agree upon which primary school or which high school a minor child should go to?
Yeah, well, I mean, we've got two options here. Either a child who's not yet attended a school, or a child is at a school, but there's a little bit of conflict about which school is right for that child. So we have to look at the child. We always do that. We always look at what would suit the child best before making any decisions. When it comes to something like schools, we need to look at the nature and the characteristics and personality of the child as a unique individual and see what requirements they have. So if they come from a certain religious background, then obviously we want to have a school that can cater for those needs. If they happen to be a child who has special needs, obviously we will want them to be in a school that can cater for those needs. But what people seem to kind of bypass a little bit is various aspects of life that get involved. So the distance of the school from the caregivers, from the parents, we often have a situation where mother and father live on opposite ends of the country, on opposite ends of the city, whatever it is. So we say really in that kind of a situation that whoever is the primary caregiver, whoever the child resides with most of the time, especially during the week, we would want to make sure that it's most suitable for that parent to be able to get them to the school. When you have a child that is already a school-going age, has already been involved in school, and we have a dispute where a parent wants to change the school. I'm actually busy dealing with one like that right now, where the father, there's a relatively 50-50 access, but the father lives on one side, the mother on the other side. So the father has to really drive an hour every day to go and take the child to school when he has the child. So where this becomes a bit complicated is that it would make much more sense to say, okay, well, let's find a school that's kind of halfway for both parents, which sounds like a quick fix. But now we look at the social dynamic. Has the child made any connections with the teachers, with the social, with the friends, and what kind of factors would be detrimental to taking that child out of the school? Parents, I need to just remind you that your children come first. And if it's a situation where it is in the best interest of your child to be at that school, you're going to have to just suck it up and drive for the hour. If we find that it's detrimental for the child to be in the car for the hour, then that's a different story completely, and that's something that we would investigate. But yeah, I think that when it comes to that, if parents can't make a decision through mediation, that is where we get potentially a parenting coordinator involved, and we look at the collateral. We get reports from principals or from religious leaders or babysitters or whoever's been involved with the child up to that point, and then we try and resolve the issue accordingly.
So, Daniella, thank you very much for that insightful information. I think it's with COVID-19 or the lockdown, parents are now in limbo as to another aspect. Should they continue homeschooling the child, or things like that, or also what type of school the child should go to? So it's really relevant, and I like how you answered it, and it will definitely assist many people in that regard. Daniella, you mentioned the term parenting coordinator. PC. Now, I've been practicing now almost for 20 years, and the first term that came in was the word facilitator. That ended about 2 years ago, sorry, and now they've brought in this new term, parenting coordinator. Can you maybe just unpack what is meant by that term?
I think the best way to explain that term is to put it next to the term mediator, so that we can establish the differences. But in a nutshell, a parenting coordinator is somebody who's brought into the process by court-ordered appointment, or within a mediated parenting plan. There's always a clause to say, if we face difficulties or conflicts in the future, although we've got this parenting plan, who do we go to? So the parenting coordinator is basically your go-to person to resolve conflict. The difference between a mediator and a parenting coordinator is that a parenting coordinator has got the authority to issue directives, whereas a mediator does not. So I work as both a mediator and a parenting coordinator. And in my mediation cases, I sit there as a completely neutral third party and listen to both sides and try and help my clients come to an amicable resolution. But if they can't, then 9 times out of 10, then we go to litigation. As a parenting coordinator, I sit there as well as a neutral third party listening to the couple disagree. And then it is my job to collect collateral. I have the authority to interview children, teachers, grandparents, whatever, and then make a recommendation according to my findings of what is to be in the best interest of the child, and then issue that directive and say, you know what, you guys can't agree which school to go to. I, as the PC, am going to collect all the collateral, conduct all the interviews, do all of that kind of stuff. I will then issue a comprehensive report about why I have decided that school A is better. Here you go. This is now what we're going to do. The one thing, though, that we have to remember is that although it sounds, I suppose, glamorous in a way, we cannot enforce these directives that we issue. So I can say you have to go to school A. That's my findings. Thank you very much. But if you don't do it, then there's no recourse. which is a little bit of a problem for parenting coordination, I think, as a discipline. That's a fundamental difference and really the fundamental purpose of a PC.
Yeah, thank you for that, Daniela. And the difficulty which I have, and you have the same difficulty, is the powers of the parenting coordinator. The actual, what does it mean? You know, you can make directives, but if the parties do not want to adhere to those directives, it's basically useless. Back in the day, and all referring to for the previous more than 2 years ago, where the term facilitation was still used, those facilitators could have made, you know, binding directives that has the authority of a court order, but it has been challenged, and the courts have, you know, looked differently at it afterwards. My view is that we need to, for the sake of the minor child and the sake of the parties, there needs to be some type of stronger authority on the parenting coordinator. Because what's the use? You go to the High Court, you spend so much money on getting an order, or the Children's Court, whatever the case may be. You appoint a parenting coordinator, which job is to avoid the parties from going to court in the first place, and try to resolve matters. You know, the squashy court room with a coordinator. And if that fails, the parties are still left to go back to court, which is obviously a bit of a waste of time, because the parenting coordinator could have made a directive, and more than likely the court would have accepted in any event. Daniela, thank you for that. So Daniela, let's move forward onto something else. You can maybe advise me and assist me on this issue concerning the mediation process itself. On child maintenance, can mediators be of much use on the issue of child maintenance?
Question and a fun topic, and I mean that sarcastically. Okay, so mediation, if it is attended for the right reasons at the right time in the process, can be extremely valuable. And the reason I say it that way is because if you're getting divorced and you go to your attorneys, the first thing they're going to do is say, we are going to win this. We're going to fight until we win. What do you want? I want 10 Rand. No, we can get 100 Rand. Let's fight. And then all these ideas get put into the parties' minds. They're going to win. They're going to clean the other one out. They're going to get all their money. They're going to get the house, this and then the other. And then it becomes a huge, big fight. And I'm sorry, like, I don't mean any offense, obviously, but that is what a lawyer's job is, you know, to win for his or her client. If you come to mediation before you get to that process, and you sit down and you speak to the mediator and learn your rights and learn what is best for everybody, because even though we are a family system that are now breaking apart, we will forever be a family system. And whatever happens to mom is going to affect dad and is going to affect the kids, regardless of how many years they've been divorced or what the story is. So if you come to that process and you get, you learn exactly what the story is, what your rights are, what your responsibilities are, then we can kind of sit and work things out logically and relatively calmly. So one thing that I do when we work out maintenance, the first thing I do is I say I'm not here to listen to your emotional states around finances, because maintenance always is where everything turns sour, always. So I'll say, okay, I understand that you want the money. I understand you don't want to pay the money, whatever the story is. Let's go back to basics. And instead of saying how much money everybody needs, let's figure out exactly how much money the children need. And then we work out, okay, the children have got 2 columns. The one is everything that they need, their requirements to survive and to be able to be afforded a decent enough life, schooling, medical, a house, a roof over their head, all of that. And then the second column is luxuries. So we'll say, okay, extra cricket lessons and music lessons. These are things that are not a requirement to be able to survive. And when we work all of that out, we can say, did you know that your child is costing you 16,792 Rand a month? No, I didn't realize it. Okay, so now we look at that and we say, out of that money, ideally we want 50-50 from each parent, but then we have to also take into account that affordability does play a role in this as well. So following my process, it could be easy enough. It's very systematic. It's very unemotional. We work only on facts. And then we get the amounts and say, okay, Dad earns 100,000 Rand, mom earns 20,000 Rand. Dad's got 5 times more money, disposable income to be able to pay for the kids. So then we work everything out. And legally speaking, and if you were to go to the maintenance court, you would find that mom might have to pay 4,000 Rand and dad might have to pay 12,000 Rand. So where mediation helps with this is if we keep it systematic and we follow the letter of the law, so to speak, we can't go wrong in terms of the baseline. Where it gets exciting, though, is when dad says, okay, well, just because I got a better job doesn't mean I should be more responsible than you. And this is where we either sit down in mediation or in therapy or with lawyers or whatever and resolve it, or this is where you end up going to maintenance court. So mediation does help, but it depends on what kind of person you are, and it depends on how much you really want to resolve it or how much you really want to fight.
Daniella, thank you very much for that. I like the one term you use, systematic. And in any legal process, you need to be systematic. You can be a mediator or facilitator or parenting coordinator, whatever, even an attorney or advocate dealing with a matter. If you do not have a logical and systematic approach on how to deal with matters, people won't understand what you're saying. They wouldn't know what you're talking about. They'll just agree with you all the time, but that's not really the case. And the whole purpose behind the mediation or facilitation process is wasted. People spend time, they go through the motions, but there's no value to the actual outcome. So I like what you mentioned over the systematic, and what you mentioned now is obviously systematic. Daniella, one unique thing about you as a counselor is that you also think like a lawyer. I'll be honest with you, because that's the approach which we have to, that's how we have to deal with matters, law, logic, etc. And you cannot do your job in isolation of the law. That's very important for any professional. Yeah, that's why they're coming to you, because.
So the thing is that I have had a couple of clients that have come to me as a mediator from failed mediation in the past. And when I read mediation reports and all of that kind of stuff, you could see that they were not adhering to any part of the Children's Act or anything like that. And then you sit there and you wonder, like, it's not a wonder you didn't get anywhere, because none of this actually would hold in court were you to go, should you go to litigation and say, well, mediation failed. If I was a magistrate in that situation, I'd say, this is not mediation, let's try again, So it's very important that you make sure that you go to somebody who can actually assist in the way that they say they can.
No, Daniella, thank you very much for that. Many times, I'll be honest with you, matters go to court, and they get litigated, and people spend thousands of rands on, sometimes hundreds of thousands of rands, millions. It happens not on my role, but it happens on legal matters where the issues could have been resolved with a good mediator. Full stop. Nothing else I want to mention, because what happens is they spend all that money. At the end of the day, they go to a court of law, they go in front of the judge, and the judge now spends time with these people. And they mediate, they resolve these issues. But what happens is the lawyers want to make money on both sides. They want to drain the clients, and it happens on a regular basis. I'm not referring to any specific lawyer, but it happens. And once the money gets drained up, there is no money left for mediation, or the idea of mediation gets swayed away because it should have been mentioned in the first place, and it wasn't. So, Daniella, that's what I'm picking up.
The problem is that after that whole process, there's no money left for the kids, and that is what the biggest problem is. And some people get so involved in the need and the desire to win that they would much rather give the lawyer the R1 million than give it to the ex-partner. Because then it looks like if they give it to the ex-partner, who will then use it for the kids, they feel like a failure. I mean, there is so much education that needs to be put out there, to show what this actual process is all about. And ultimately, it is all about the kids and their future, end of story.
Daniella, we need more people like you in trying to resolve these matters. And sometimes it happens that facilitators and mediators as well, they also, their job is not necessarily to try to resolve the matter. Their job is to bill as much as they can, to have as much sessions as possible. So if the package is 20 sessions, we'll bill for 20 sessions, as opposed to having the matter resolved there and then. And Danny,
this is the thing, and I think that. Sorry, carry on.
No, go ahead. I like listening to you. Go ahead.
Oh, I was going to say that I think the I always urge people to make sure that they've got an accredited mediator, because when there's a governing body involved, then you've got a different ball game. Like, it's part of an ethical code to know when to give up, you know? As a professional, if I can see there's no resolution after 4 or 5 sessions, and I can see there is no possible way of bringing this together, that it's my ethical duty to stop, you know, and to say, maybe you're not gelling with me as a person. I mean, that's very possible. Maybe you need to try a different, maybe you need a legal mediator, you know. So it's up to us as professionals to make sure that we're not taking advantage of our clients as well.
And that seems to be the problem. People want to make money off you as opposed to trying to assist you. Obviously, there's nothing wrong with billing and making money off a client. It's important that you earn your fees. But at the end of the day, not to the prejudice of the client. From a professional point of view, for example, let's say a client comes to my office and I know this client doesn't have any rights. He doesn't have any rights to X, Y, and Z. Let's say the father that never saw his child for many years, he wasn't involved in the child's life. And now he comes to my office and said, you know, advocate, I would like to have overnight contact with my child from this weekend, immediately. The child doesn't know who he is. And I continue with the conversation. I tell him, no, don't worry, let me send a letter out first. Sent the mother, and I know the mother's unreasonable, she's saying no. And we just bill the client, make money off the client. And said, no, let's go to court. Let us start an advocate, you know, let's fight it. Knowing full well that you will be unsuccessful in your case. And that's not on. That shouldn't happen.
Okay. Exactly.
Yeah. So,
exactly.
Daniella, let's move on to another topic. Parenting plans, like the drafting of parenting plans. How much involved do you get in the drafting of it? I understand the mediation of a problem, but the actual unpacking of it, the weekend contact, overnight contacts, school holidays, religious holidays, how much involved do you get in the drafting of it, compiling it?
I draft all of my own parenting plans. So I take it really from conception to reality to implementation. So what that means is that I will have the initial sessions, mediation sessions. I have my lists of, like, my checklists, so to speak, of all the things that we need to unpack and we need to resolve. I then obviously record everything that I have heard from both parties. I make sure that it's agreeable. And then once I've got everything down, then I will do a first draft, and all of that information will appear in that parenting plan. I would then send that off to both parties for review, and then they can bring up any concerns that they might have. If I've misunderstood anything, then that's their opportunity then to say, no, I didn't agree to that, whatever the story is. But ultimately, I draft the entire thing, and then I give it to them in their final session. Once everything's agreeable, they sign it in front of me, I witness it, and then they each get copies to take to their respective attorneys if they've got. Otherwise, they take it to the court if they are going to be doing putting the divorce through themselves, whatever the story is. But it's important to note that this parenting plan does get annexed to the final divorce order. So it becomes part of the court order. And that's important to know. Just one more thing, though, as well, is that in mediation, that is your time to speak up. If you have got a concern or an issue, that is your time. Do not go and see a mediator and say, yes, I agree he can have the kids every second weekend, and then afterwards change your mind and say, oh, you know what, I don't think the kids are safe there. Because that is an entirely different situation now. If you don't feel your kids are safe with your ex-spouse, if you don't agree with anything, please bring it up immediately, because if you don't, it will cause trouble later. And that opens a whole can of worms with having now to go and obtain forensic assessments to verify your concerns. And then we're looking at a process that can literally be 2 weeks is now turned into 6 to 8 months. And this is just to draft a parenting plan. This is before we can even go and apply for the divorce. So to answer your question, I do all of that, and I draft it myself, and I get it all ready for court.
Danielle, it's really useful that the person that does the mediation has the skills to draft the parenting plan, because sometimes when they go to a lawyer, the lawyer might have a different outlook on the provisions that were agreed upon. So let us say you spent quite a quite a lot of time dealing with one specific aspect. Let's say, for example, overnight contact. And the parties agree that overnight contact will only be on a Saturday evening, so that they agreed upon it after spending 4 hours on mediation. Now you go to an attorney to draft this parenting plan. His view or her view might be, no man, it's unfair. Then he repacks it again, not unpack it. He repacks the whole problem again, which is not obviously the best way to deal with the matter. So if you draft it well and you present it to the attorney knows he must just legalize it and make it an order of court.
Exactly. And the rule of thumb for me, at least, is the more information, the better. If I've got a parenting plan that is 600 pages long but covers everything, then I'm sorry for the clerk and the whoever's involved. That's just how it is. So I like what you said there. I might say I've spent 4 hours with this couple now with overnight contact, but there's an underlying issue with regards to sleep anxiety in the child. I will make sure that in that parenting plan, there is some sort of clause that states that should the child suffer from a heightened whatever of sleep anxiety that particular night, then the father will let the child sleep in his bed. That's a stupid example, but I will extend it that far so that when the child comes home and didn't sleep a wink that night, and then the mother gets all angry, we've got something to fall back on. And this is what I say to everybody, is I don't care how wonderful your relationship was. I don't care if you think that even though you're separating, you've got the best ex-spouse in the world. We never know how people are going to react to anything. And anything that you can have on paper, signed in black and white, is just going to make your life easier going forward. You never know. Dad might say, I want my child to have everything of the best, only I'll pay for it all. Then all of a sudden, 2 years down the line, he remarries and has other kids. Now everything changes. No, you know what? I've now got 3 children I have to support, not just one. Now I'm not allowing this child to do horse riding anymore, and we're selling a horse. Now there's a big problem. What are we going to do about it? So that is where I find a lot of arguments and conflict comes up later in the co-parenting system. So it doesn't matter. We've got a parenting plan here. That's wonderful. But now everything's changing. So where do we turn to? And we turn back to the parenting plan and the maintenance plan and all of that kind of stuff. If we do not have that in place, then we've got a big problem. Number 2 is if we don't update it regularly enough. Like when I say update it regularly enough, I always put a clause in my parenting plan that says that this can be amended from time to time. So now the child gets older and the child's needs change. And in my parenting plan, I've got there that dad's going to have a sleepover with the son every Saturday night. Now the son has turned 14 and wants more contact with his dad and whatever. And mom says, yes, that's fine. Let's do it. 1 week on, 1 week off. Perfect. Child's happy, mom's happy, dad's happy. Dad remarries, mom's pissed off. No, you can't have 1 week on, 1 week off. Where do we fall back to immediately in conflict? The parenting plan. But in the parenting plan now, all of a sudden it says only every Saturday. How do we tell this child now, sorry, you can't see dad 7 days anymore. You only see him once a week. That's not fair. But there's nothing else we can do other than fall back on whatever legal document we had in place. That is why we need to keep on top of this to avoid conflict. If anything, a parenting plan is to avoid future conflict.
Yeah, Daniella, you're 100% right. The idea is the plan. So the parents who are obviously very amiable with each other, they're amicable, they're friendly, and they divorce on a friendly basis, their plan will be different than a high conflict separation divorce. Their plan will be more mellow, more easier to work with because that's their personality and that's the issues involved. And also depending on the age of the child. If the child is 17 or 15 years old, the plan will be a bit less rigid because the child might decide, no, this weekend I want to be with mom, despite the order saying that you should be with dad, because things are different. Daniella, this is a question I want to ask you, and maybe it's a repeat from previous questions, but you answered it very well previously. What happens if how do you deal with the issue where you have 2 people in the same room with you? Both of them never spoke to each other for the last 5 years. They were embroiled in litigation for the last 5 years. They finally got them in the same room. Mom speaks, dad doesn't listen, or he makes like he listens and he's preparing his argument, and the vice versa for dad. How do you deal with that? Do you specifically, Daniella and Mair, deal with such a high conflict situation?
You have answered this question before. So I'm going to answer it how I feel today. No, to be honest, my role here is, like I've said before, to be the outside neutral third party. I often deal with cases where to get two people in a room together is like a close to impossible task. That when they actually do come together, it's such a miracle that I'm going to do my damnedest to make sure that they both stay there for the duration of the session. So what I always like to say is that we need to break through the boundaries of the ego in the situation. Make sure that the couple, both parties, understand what the session is about, understand that I as a mediator am not there to judge them in any way, shape or form. I'm there merely to assist them and to make sure that both of them feel heard. So when mom's talking and dad's not listening and he's just preparing his response and whatever, my job is to make sure that I've heard the mom. And my job would then be to direct the feedback to the dad and say, have you heard what has been said? How does it make you feel, what you've heard now, and try and navigate it that way. Because the one thing is that we always, in conflict, we don't listen to hear, we listen to answer. So we don't really hear what the other party is feeling or thinking. To us, we don't really care because we come in there wanting to win the session. So a lot of the time, I've had it so many times recently where I've got one person saying something and the other person has prepared this whole response almost like beforehand and said, if she says money, I'm going to say X. That it is completely unrelated to the question. The answer and the question are completely unrelated. It's actually quite funny to hear sometimes. But what my job is to make sure that both parties feel comfortable enough and safe enough in my environment that they are able to open up and to listen to each other. Another vital role of my job is to be able to manage them and to say, you know what, if you're going to speak to each other like that, you can leave, which is something we don't want to do, but it's something that's quite effective because when adults are treated like children, sometimes they have to be, then they kind of like, they stop and they listen. So, I mean, I've got a poster of house rules in my office, and I go through them beforehand and I say, we will treat each other with respect. It's like primary school. We will treat each other with respect. There will be no bad language or name calling or whatever used, etc., etc. And then I need to now gain the trust of both parties that if he says, oh, she's such a bad mom, that I'm going to call that out. The same way, if she says he's such a bad dad, I'm going to call them out. So there has to be that trust developed between the mediator and the couple. But the one thing that I wish more people would acknowledge is the realities of what divorce or separation actually is, because that can like really steer you in a much more friendly or in an easier direction. Is that when you go into a divorce process or mediation, to already know that it's not pretty, it is one of the most stressful life events ever. The breakdown of a relationship, especially if it's been quite a long one, it's got the same brain process as the loss of a loved one. The loss of the relationship is something that needs to be grieved. So what I kind of urge people to do is to say, you know what, don't do the divorce right the second while you're grieving the loss of the relationship. Let's take a step back. Let's actually go through the motions of the grieving process, the anger, the acceptance, like the whole process of 5 stages. And once you've gotten to a place of more acceptance, then we'll get into the nitty-gritty of it. This is not always something that is practical because we've got kids involved and sometimes we need answers immediately. But that is where I come in, where it's my job to kind of make sure that I can keep your cool for you. I can be here that when you start moaning about something and crying because it's so emotional, that I can be the one to tighten the reins and say, you know what, that needs to be dealt with in private therapy. Let's put that aside for a second and let's just deal with what needs to be dealt with now, right now. Is the dad a good dad? Yes. Are the kids going to be safe with him? Yes. That's all I care about right now. You've said they're going to be safe. You said that they are okay, that he's a good dad, that he loves his kids. There's no reason now to open a can of worms about the emotion behind why you don't want them there. Until we've got that down and we've got that sorted out, let's put an interim plan in place, and we'll come back and adjust it later once everybody's kind of like calmed down. So with that, there's also exercises that I like to ask people to do that are sometimes, it's a little bit out of the box kind of thing, but these exercises are something that I like to ask people to do. They don't have to share it with me. They don't have to share it with anybody. And it's easier, I think, to do exercises sometimes where you don't have to share it, because to be able to sit down and try and think objectively about your situation is valuable. So I like to say, write me a list of points about all the positive things about your ex-spouse. Nothing negative, everything you can think of throughout your relationship, parenthood, whatever that's positive, write that list down. Then put yourself in your children's shoes and see, if I was not here, what kind of relationship do my kids have in isolation with the other parent? And write that down and be honest, because nobody's going to be seeing this. So if you write there, the kids have a strong relationship with dad, you're not going to be bound to that because nobody's going to know except for you. So be honest in the process. And the other thing that I find valuable is to take yourself out of the situation completely and pretend that your situation is your best friend. And run through all the things and think, how would I advise my best friend to deal with this situation? If you can do that, which is a much easier said than done, but if you can do that, then you start looking at everything more objectively and you take the emotion out of it for now and you say, these are the facts, these are the resolutions, and then you make a list of all the emotional things that you want to attack the other person for. That's fine. And it's important to get that out, and it's important to deal with those things. But you need to know the time and the place, and in mediation is not the place.
Daniella, thank you very much for that. And you explained it so well, and I wish I could do it as well as you do. My job, it doesn't entail mediating. My job entails, just arguing and fighting. But what I love about your style is you have a system. You have a mechanism of how to deal with certain type of chaos in a mediation session, as opposed to someone, there's a fire, he doesn't know what to do. He'll throw stuff on it and try his best to put it out. Whereby another person will have a plan. This is how we'll deal with it. We'll control it. We will, throw water on the sides. We'll use this or that. So Daniella, I love it, and I always learn from you. I learned more from you. I learned a bit more from you from your previous explanation, and I'm certain, should I ask this question to you the next time, I will learn much more. And it's very important, because the challenge is, if the parties don't come to the meeting with a mission to resolve issues, they will not resolve the issues. If the clients, if I'm litigating, I tell my client, we will not agree upon the other party's proposal, but going to the meeting and just go through the motions, we're just wasting everybody else's time. And Daniella, you're 100% right. Parties going to these type of meetings, they preempt the questions that will be posed, the comments that will be made. The moment he mentions his mommy's name or his sister's name or his new girlfriend's name, the mother has a response, and vice versa. So that's very wonderful. Daniella, now my last question to you, I think, we're on a 40-minute pathway over here. On child custody and divorce matters, right? When parties are embroiled in litigation, they're embroiled in litigation, is it advisable, is it possible for them to come see you while they're embroiled in litigation? So they have advocates attorneys on the one side, they have advocates attorneys on the other side, they at a block, they cannot go further. Would you be able to assist? I know you can, but how would you deal with such a situation?
So I think that, when it's something that's so involved in terms of attorneys and advocates and whatever that are already appointed and representing or whatever, I don't like to get involved in other people's processes, let's put it that way. So I do get involved, so don't get me wrong. Very often I've got that where I'm busy now dealing with each party's representation and, answering questions back and forth. I have meetings with family advocates to discuss those cases cases, you know, but I prefer to be involved with those when they come from the family advocate's office themselves, you know. And then I am kind of given a mandate from the advocate to say, this is where we're at, this is what we have a problem with. And then I will see how I can assist in that kind of a situation, be it as a mediator, be it as a parenting coordinator. I had a meeting with one of the family advocates a few weeks ago, and we decided the best way forward was to appoint me as the PC, which then gave me a whole different list of powers. It might even come up that the way that I can help is as a family therapist. So yes, I do definitely get involved. I always feel that the more psychological intervention at that kind of point, the better. So that would be a slightly different aim, though. It wouldn't be to now decide a parenting plan or to decide a maintenance plan. It would be to uncover the layers of why they are not moving forward. And that's a complete psychological process. So that would involve joint sessions with them, perhaps even caucus sessions with them, where I can speak to them individually, with the understanding that what is shared there is transparency. But yeah, so that is kind of the involvement at that level that I have.
Daniella, thank you very much for that. Daniella, I would, compare litigation whereby you're a client, you're a normal person, you may be an accountant or a doctor, whatever you are, you're an individual. Here at the back you have this advocate, this attorney, and this whole court, behind you, and the other party as well. And you're the pilot of the small, you're the pilot of this tank, and you're going to battle the other party. There will be fighting, there will be shots, people will get injured, and that's the reality of litigation. It doesn't go down nicely. So you can be the simple person, this down-to-earth person that never ever fought, won't hurt a fly. But the mere fact that you are appointing attorneys and advocates or taking your battle to the court means that much more than a fly will be hurt. The tank will be shot at, there will be bombs taking place, etc. So that's really important to note when you start going to litigation theorem. But Daniella, on the last point, I agree with you. It's easier if you have a specific mandate from the court, specifically advising you. These are the parties that are embroiled in litigation. The court matter is in 3-4 weeks' time. Please assist the parties in mediating X, Y, and Z. So I have a specific mandate. And the parties are forced to cooperate because the court forced them to cooperate.
Exactly, yeah. But the thing is that, like you said, now you go to battle, you're an innocent little whatever, you're a stay-at-home mom, you're a baker, you are a welder, whatever the story is, you've never ever dealt with conflict on this level before, and now you're going to battle. The one thing that you need to at least do is prepare yourself. Yes. You at least need to know the process. You at least, I do this for a living, I'm busy studying law. And it took me forever to understand the difference between an attorney and an advocate. It sounds stupid, but you need to know the role players in your process. You need to know why a social worker is being called. You need to know why the advocate is there. Why does this one have an advocate and this one self-representing? You need to know all of these things so that you're at least prepared for what's going on. Never mind the outcome, but who do you need to fight for you, or who do you need to respond to? And you need to have all these concepts completely waxed before you even enter that courtroom. Otherwise, what are you doing there? It's just a recipe for disaster.
Yeah, I would say maybe a different example is like starting a car. That small, ignition, it pumps the engine, petrol gets burnt, a lot of things happen. That's what happens if you start litigating. You are entering into that battlefield, and my advice to you is please stay out of that, because if you have a strong advocate is willing to fight, an attorney is willing to fight, and the other party is exactly the same, you started a war. And you're 100% right. You might have been a very pacifist type of person, never involved in wars before, but here you started a war. There's judges involved, there's family advocates involved, there's counsels involved, there's court clerks involved, there's so many things involved. Automatically your name appears on a court roll. You Google your name in the High Court of South Africa in the matter of A versus B. You become public. Your life becomes public. There's a file. Your data is all in the court file. People can pick it up. They can know all your details. So before we go into a war, mediate. Speak to Daniella. Daniella, that's my final point on my side. Any final comments on yours?
very much. No, that's all I have too. But it was a pleasure to have this chat. And yeah, if anybody needs any assistance with anything, please don't hesitate to contact me.
Daniella, yes, I see we have a comment on our Facebook chat. Let me just deal with that. My apologies for not getting back to you earlier. Maybe I can just read it out and we can deal with that quickly. The question is as follows. Does the primary caregiver have to contribute just as much as the other parent? Child is living with primary caregiver, houses, feeds, and rears the child. Other parent sees the child only every second weekend or month. As a child maintenance issue, does the primary caregiver have to contribute just as much as other parents? I always say the primary caregiver is contributing much more. Time, energy, sleepless nights, etc. You might not be contributing as much financially than the other party, but losing sleep, rearing a child, making a child, teaching a child how to walk, how to potty, etc., that in itself is invaluable. Daniella, do you want to give a go, that question a go? Should a primary caregiver pay the same?
I do quickly. I just want to say that there's two things to say. Number one is that that's all taken into account in a maintenance plan. Is that because you don't have the child as often, the portion of rent that you pay for the child is much less, the amount of groceries you buy for the child is much less. So in that form that I was saying in the beginning, where you write down the groceries for the child, all the expenses, then dad will be 200 Rand, mom will be 2,000 Rand. We join those two together and then each parent pays a portion. So we do take all of those factors into account. But the other thing I just want to state, and this is where it becomes unfair, is that the person who is named the primary caregiver, because they have the kids more often, whatever shortfall there is from the other parent, unfortunately automatically falls onto the primary. I'm never going to say I've got my son 5 days, dad's got my son 2 days. I can only afford to feed my child for 3 days, but dad doesn't care. Therefore, my child's going to starve for the other 2 days. It is up to me to make sure that my child's got food for 5 days. So that is where the fight always comes in. What if my child needs psychological help, but I don't have the money to pay for it? Either the child doesn't get the help, or I have to sit there and beg the other party to pay for it. If the child needs it, has to have it, let's pretend it's court ordered and dad still doesn't want to pay for it, I'm going to have to. I'm going to have to find a way. So that's where it becomes unfair. But again, everything gets worked out according to affordability, but also to be as fair as possible. Both parents brought this child into the world. Both must keep them alive. End of story.
Daniella, thank you very much for that. I don't think I have to go further on that issue. Another comment, what about psychopathology? That's a comment the person made. And the other comment was that's a difficult exercise. Any comments on those two comments? I don't know how to take it further.
So the exercise is very difficult because it's very difficult to be objective. And when you are so emotional, it is very difficult to take yourself out of the situation. But it's something that can be practiced, and over time you can get better and better at it. Another thing also on those exercises, they're a bit difficult. It's very valuable to join a support group or something of people that are going through the same thing, to hear their stories and to try and assist with them, because that often shines a light back on you that you never even realized. It might show you perspectives you never even thought of, and their relevance to your case would be very helpful. When it comes to psychopathology, now we have got a completely different ballgame. Psychopathology is obviously, it entails things like mental and emotional disorders and all that kind of stuff. And I would imagine we're leaning towards something like bipolar or narcissistic personality disorder, intermittent explosive disorder, schizophrenia, all those kind of things. When we have a parent that we feel, okay, so we get two parents, either one who has got a disorder like that, or we have a parent who is accusing another parent of having it. Either way, we take that very seriously and we do all the investigation we need to do, because we need to make sure the children are safe. So whether we've got a mother who is a primary caregiver but also has bipolar disorder, provided that that mother has got it under control and is taking medication for it and general checkups or whatever with her psychiatrist, then we deem that to be a fit parent. If we've got somebody who is not taking those measures to make sure the child is safe and that they're emotionally capable, then that is an unsafe parent. And then we kind of lean towards placing that kind of a child in need of care and protection, which is something that we don't want to go to ever. But yeah, so if there's psychopathology issues or questions at play, we definitely refer to psychiatrists for full reports, because that's not something at all that we'll ever like mess around with.
Daniela, thank you very much for that. Thank you for those comments. Much appreciated. Then there was one question while we're on this topic. If what did you suggest should happen, for not from a mediation point of view, from a psychological point of view, if the parents are involved in high conflict, in the sense of whenever they have contact with a minor child, when one party has contact with a minor child, the parents are always fighting in front of the minor child. You know, they're acting, maybe not physically fighting, but they're arguing, etc. They're high conflict. Would you advise that, pending the outcome of an investigation, etc., that the minor child be placed in foster care, in the care of a third party? What is your view on taking the child out of the situation, away from the mom and dad, in high conflict situations?
So it depends entirely on that situation in isolation. So there are so many variables at play, but let's elaborate that to a couple that are separated, and mom and dad, neither of them have got a good enough parenting capacity to care for their child. Then of course we're going to take them out of their care. Ideally put them in third-party care with a family member or somebody that they know that can look after them adequately enough in the interim. So be it the grandparents or whatever the story is. If there's nobody available to take the child, then they will go into foster care. When we've got a situation where there's high conflict and mom is accused of having schizophrenia and dad is capable of looking after the child, then we would look at something. This is all once we've resolved that or decided that there actually is a psychopathology at play or abuse problems or something that's real and relevant. Then we will take that child in the interim and award primary care or sole care to the one parent that is capable of looking after the child. Ideally, and in the court process, the absolute last thing that any of us want to do is remove a child from their parents. That is like a dire situation. That's not something we ever want to have to resort to. And another aspect of all of this is also what is the age of the child? What is the child accustomed to? To take a 12-year-old away from her mom for nonsense or for fighting or conflict is going to be extremely traumatic. End of story. It's going to be traumatic. So is it really the most useful and beneficial thing for that child? And that's where the difficulty comes in, because we have to make that call. A baby, for example, who has got a mother who is her primary carer, let's say the mother's still breastfeeding the child, but the mother is a drug addict, there is no world that is a good enough environment for that child. So then we kind of weigh up the psychological damage and trauma versus the actual survival, of this child. And we say, okay, well, we know that we're going to have to deal with this child in the future on a psychological level, and we're going to have a lot of therapeutic intervention, but we want to do that with a child that's alive, We're taking it away from mom. Sorry. We're taking it away. I mean, what is we look back at the human rights. What are our human rights? And the right to life, I mean, that's completely not negotiable. So we have to kind of weigh every situation up in isolation and see whether it's causing so much harm to the child that it's going to be detrimental long term, and then we try everything that we can first to rectify that. And if we can't, then we are unfortunately going to have to place that child in some sort of protection.
Yeah, Danielle, it's a very difficult question to answer, because does the court have to make a quick decision and say the dad is at fault or the mom is at fault? Because sometimes both parties are at fault. The mother might be a wonderful person, the dad might be a bit of a rude guy, but she is the one that spur him on to act in that specific way. But Daniela, that's a very difficult question I asked you, extremely difficult, and I'm glad you could have answered it, and much appreciated. That's it on my side. From our side, Daniela, thank you for your time. It's always wonderful. Stay on the line quickly after this. I want to chat to you quickly via the Zoom. But to all the participants, thank you very much, and hope to see you online again soon. Have a lovely day.